Hello students, welcome to EPG Pathshala. I am Dr. Arun Singh Thakur from University Institute of Hotel and Tourism Management, Punjab University, Chandigarh. Today we are going to discuss about the module Indian Contract Act 1872 from the paper Tourism and Hospitality, Entrepreneurship and Legal Environment. The present module deals with understanding the law Indian Contract Act 1872. After studying this module, you will be able to define the term contract, know about the parties to contract, comprehend essentials of a valid contract, and pen down the different types of contract. Operating business is a relative term, requires contracting among many stakeholders. There must be a clear understanding among the various parties involved in the business. This understanding is derived through a written document between the parties with intention of righteous conduct. Such documents are called as contract. In India, the provisions for entering into contracts are laid down by the Indian Contract Act 1872. The Act addresses all the legalities for entering into the contract, which is legally enforceable and thus called as a valid contract. A contract between the parties must satisfy few essential things to be considered it as a valid contract. According to Section 10 of Indian Contract Act, all agreements are contracts if they are made by free consent of the parties competent to contract for a lawful consideration and with lawful object, and not hereby expressly declared to be void. Here are the essential elements for making a contract valid. Now, dear students, we'll discuss what is law, a rule or body of rules essential for binding a human society. It is defined as the rule of conduct and ethics that guide all people. Without law, there can be no public order and policy. Law and society are related to each other. Nothing can explain without any of them. Law also need to be changed according to the changes the society faces, because without the necessary changes, law cannot keep pace with society. Without the control of the law, the society became jungle or at least barbaric. So to keep the society peaceful, we need to create a harmonious relationship between law and society. Meaning of contract. A contract is a legal binding or valid agreement between two parties. It can be defined as an agreement enforceable before the law. The law will consider a contract to be valid if the agreement contains all of the following elements. The first is offer and acceptance. Second is an intention between the parties to create binding relations. Third one is consideration to be paid for the promise made. Then legal capacity of the parties to act. Fifth point is genuine consent of the parties. And lastly and importantly, legality of the agreement. An agreement that lacks one or more of the elements listed above is not a valid contract. Each of these elements is dealt with in more detail in this module. This flowchart is for making a contract. Proposal is there, then promise must be there, consideration for the contract, agreement between the party, and after the agreement, one is the contract which is legally enforceable, which is called as valid contract, and that can be voidable agreement, which we'll discuss further in the module, and the other agreement can be legally not enforceable from the beginning and will be called as void agreement. Further, we'll discuss the title, extent and commencement of Indian Contract Act 1872. This act may be called as Indian Contract Act 1872 it extends to the whole of India except the state of Jammu and Kashmir, and it shall come into force on the first day of September 1872. For the interpretation of this, we can say that when one person signifies to another his willingness to do or abstain from doing anything with the view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. When a person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. The person making the proposal is called promisor, and the person accepting the proposal is called promisee. When at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do or to abstain from doing something, such act or abstinence or promise is called as consideration for the promise. Every promise and every set of promises forming the consideration for each other is an agreement. Promises which form the consideration or part of consideration for each other are called reciprocal promises. An agreement not enforceable by law is said to be void. An agreement enforceable by law is called as a contract. An agreement which is enforceable by law at the option of one or more of the parties thereto, but not the option of the other or the others, is a voidable contract. And a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. After this technical explanation of the terms in contract, we'll try to define contract. An agreement with specific terms between two or more persons or entitles in which there is a promise to do something in return for a valuable benefit known as consideration. Since the law of contract is at the heart of most business dealings, so its knowledge to every entrepreneur is important. What are the various stages of a contract? First is proposal, then promise, after that consideration, becomes agreement, and finally will be called as contract. It may be void, it may be voidable, or it may be valid. We'll define promise. When a person made a proposal to another and second person agrees to accept the proposal, it is said to be promise. Now, what is offer? When a person made a proposal, when he signifies to another his willingness to do or to abstain from doing something, is called as offer. Agreement is equal to offer plus acceptance. Here it is important to mention that all the agreements are contracts, but all the contracts are not agreements. The point-wise description as first, a mutual agreement between the parties to contract. The parties to the contract must be agreed through a formal agreement following an offer or proposal by one party to another and acceptance of the same by other party. The offer as well as acceptance of the offer must be in accordance to a prescribed mode between the parties to contract. The agreed contract between the parties should not suffer from mistake or should not be impossible to perform. There must be intention to create a legal relationship which is legal in the eyes of the court. The basis for the parties entering into contract should be legal, and their intention must be to create a legal relationship between them. If such intention of creating legal relationship is missing, there will be no contract among the parties. parties must be agreed through a free consent. When two or more persons agreed upon same thing by the understanding and in the same sense is called as they have consented. The consent of the other party should not be acquired by any undue influence or through force. So, consent should not be as a result of concealment of the facts or through misleading the individual. For example, in case of a dacoit obtain certain goods from the individual at a gunpoint, can retains the possession of the goods until the actual owners claim the goods back. In this case, maintaining the possession of the goods does not make him the owner, and thus he cannot enter into contract claiming the ownership of those goods. Here are few essentials which we'll try to understand with the help of the diagram. First is there has to be an offer followed by acceptance, the free consent of the parties, there must be a consideration, and contract will be valid only if the object is lawful, parties to the contract must be competent, and there must be intention to create legal obligation and relationship. A mutual agreement between the parties to contract, there must be intention to create a relationship which is legal. Parties must be agreed through free consent. The parties to the contract should be competent enough. Legality of the object should be there. Contract should not be declared void by the law of the land. There has to be a possibility of performance of the object in the contract, and registration and the legal compliance is required for making a contract valid. Fourth point is the parties to the contract should be competent. A minimum of 2 parties are required for a valid contract. All the parties who are entering into contract, they must be competent in all respect. A contract is legal binding, and thus parties entering into contract must have a legal capacity to justify their competency. As per the law of the land in India, anybody who is competent to enter into contract after he became major in terms of age should be of a sound mind person, of a sound mental health, and should not be in control of toxic substances. Then fifth point, emphasize upon legality of the object. There is essential element for a valid contract that is called as consideration. Any such agreement between the parties without any consideration is merely a statement, and there is no binding on the other parties. So, contracts are when the promise is made in return of something. This something is called as consideration. The sixth point is not declared void by law. Any such agreement which are not expressly declared as void according to the law of the land. In our country, the agreements which are restraining individuals from trade, restraining individuals from getting married, etc., are declared as void under Indian Contract Act of 1872. For example, Ram having 2 motorbikes, one is black in color and other is white. Ram wanted to sell his black motorbike to his friend Arjun, but Arjun is only aware about the white colored motorbike of Ram and offered to purchase it on rupees 20,000. Ram accepts his offer thinking that the offer is for the black colored motorbike. Now such contract between Ram and Arjun is void because they have not be considered as consented because they have not understood the same thing in the same sense. Types of contract. Classification on the basis of enforceability. The first type is the valid contracts. Those contracts which fulfill all the essentials according to Indian Contract Act of 1872 are called as valid contract. Such contracts are enforceable by law anywhere within the boundaries of India. The second one is the void contracts. Those contracts which are enforceable at the time of contract, but after some time it became void contract due to impossibility of the performance or maybe illegal consideration in the contract. For example, a person entered into a contract with other person, agreed him to sell his house for a sum of rupees 5 lakh. The market cost of the house was rupees 10 lakh. But due to the coercion by first person over the other, he agreed. In this case, the seller in future wants his house back and will able to prove the effect of coercion, the contract will be declared as void. For example, Ram agreed to sell his car to Arjun for amount rupees 1 lakh. For Ram, the consideration is rupees 1 lakh, and for Arjun, the consideration is car. Consideration is required evidence by law to know the intention of the parties who are entering into contract for establishing a legal relationship. Thus, consideration should be a real and not the illusion or illegal one. For example, Ram cannot offer to sell his car to Arjun for a consideration that he will help him out in a bank robbery. Another example we can take where Ram and Arjun are the competitors of each other in their business. Ram, being a big corporate house, offered money to Arjun to close down his business through a mutual agreement. Arjun subsequently shut down his business and thereafter Ram refused to pay him the money. It was held by the court that the agreement was void and thus money cannot be recovered from Ram. The next point is the possibility of performance. There should always be a possibility of performance between the parties agreeing to a contract. The possibility of performance should be finite and it should not be infinite. If the consideration is vague and not possible to perform, that means the contract cannot be enforced. For example, a person entering into contract with other person who is not alive. The next point was regarding registration and legal compliance. Any contract should be written document in a prescribed form and registered with the appropriate authorities. In absence of such registration formalities, the contract cannot be enforceable in the court of law. First is coercion, forcing a person to enter into contract by threatening him or detaining the property of the family members, such as kidnapping somebody. Such type of contract is said to have under the coercion. For example, A and B are the two persons on a water ship in some ocean. A is threatening B that if he does not sell his car for rupees 1 lakh to him, he will throw him into the water. Such contract is said to have under coercion. So the void agreements can be described as a void agreement has no legal bearing and is unenforceable by law. Parties to voided agreement have no responsibility or legal requirement to act as far as carrying out the terms of the agreement, in which cases a contract can be void. First is the lack of capacity, then mutual mistake of the fact, unlawful consideration or object, agreements without consideration, agreements in restraint of trade, uncertain agreements in case of impossible acts, and agreements contingent on impossible event. They are termed as void. Now here we'll try to make a comparison between the void agreement and void contract. An agreement is void in the beginning only and the contract can be valid at the time it was agreed upon, but later on, due to certain deficiency, it became void. Thus, void agreement can fetch you following effects. It will not be enforceable at all. The financial loss or the loss of property cannot be reverted again as the agreement is considered enforceable by law. The third category is the voidable contract. As per section 2, an agreement which is enforceable by law at the option of one or more of the parties thereto, but not the option of others, is a voidable contract. Agreement induced by coercion, undue influence, fraud, or misrepresentation are voidable at the option of the party whose consent has been so obtained. Another type of contract is illegal contract. A contract is termed as an illegal contract when it is breaching the statutory provision. Such agreements are void from the beginning and termed as illegal. For example, Ram promises to give rupees 500 to Arjun if Arjun slaps Mohan. Subsequently, Arjun slaps Mohan, and in order to fulfill the promise, Ram borrowed money from Shyam, who knows the exact purpose of borrowing. This agreement between Ram and Arjun was on illegal terms, and thus the financial transaction between Ram and Shyam are unlawful, for the recovery of which no court can provide help. Another type is unforeseeable contracts. The contracts, due to absence of certain legal formalities, for example written, registration of contract, etc., are also not unenforceable contracts. Such contracts valid in the beginning and also in the eyes of the law, but in the absence of the proof, they cannot be enforceable with the help of law. Another type of classification of contracts on the basis of mode of creation, and the first in this category is the express contracts. When the parties entering into the contract through just the words spoke by the parties are written are called as express contracts. The parties in such contracts express their intentions for the terms of contract. The second type is implied contracts. When the actions of the individuals automatically forced him to enter into the contract is called as implied contract. We can take an example to understand. A person hiring a taxi to reach a destination, he automatically by his actions enter into an implied contract with the taxi driver for paying money as fare. Another type of category of the contracts on the basis of extent of execution. The first type is executed contracts, when nothing remains pending to perform from either parties to the contract are called as executed contracts. The second type is executory contract, when there is something remains pending to perform by both the parties in future. Such type of contract is called as executory contract. For example, Ram agrees to sell his bike to Arjun for rupees 20,000. There is no other condition in this contract about the transaction to fulfill. That means both the parties have certain pending actions for the fulfillment of contract. Now here is the clarification of the terms as per Indian Contract Act. First is offer. An offer is defined as when a person made a proposal when he signifies to another his willingness to do or to abstain from doing something. And the various types of offer are express offer, when offer is given to another person either in writing or in oral. Second is implied offer, when offer is given to another person neither in writing nor in oral. Then specific offer, when offer is given to a specific person. General offer, when offer is given to entire world at large. Cross offer, when both the persons are making identical offers to each other in ignorance of others' offer. Counter offer, when both the persons are making offers to each other which are not identical in ignorance of others' offer. Acceptance, an offer is made by offerer
with the intention that must be accepted by the offerer. Acceptance is considered when other party agreed to be bound by the terms mentioned in the contract for certain consideration and conditions for a valid acceptance. To whom the offer is made can only give consent. Acceptance must be unconditional with no counter offer or condition attached to it. The communication of acceptance should be in prescribed manner. Communication by the acceptor in a reasonable time. Communication must be followed after offer. Acceptance for already rejected offer can be given after renewal of the offer. For example, Ram offered to Arjun to purchase his house for 5 lakh after 1 month. Ram gave his acceptance with the suggestion of taking possession after 2 months. Due to counter offer, the contract cannot be concluded. Free consent. It is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation or mistake. A contract without free consent is voidable contract.
Another case, a young widow was forced to adopt a boy by her relatives who prevented the removal of his husband's body for cremation until she consented. Held that the consent was not free but was induced by coercion. Consequently, the adoption was set aside. Another case, an agent refused to hand over the accounts of the books of the business to the new agent until the principal released him from all liabilities. The principal had to give release deed, held that the deed was under the coercion and was voidable at the option of the principal.
What is undue influence? A contract is said to be induced by undue influence where the relations between the parties are such that one of the party is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. There can be an undue influence among the following persons: owner and the worker, between the senior and the junior, between mother and daughter, between a professor and a student, between managing director and organization, and leaders and the followers. What is considered as fraud? Fraud is considered as an act which a person intended to enter into the contract. Here, the concealment of the information, presenting or false fact as truth, making a promise without any intention of fulfilling it, and intention to deceive somebody are certain criteria for declaration a contract as fraud. Further, we'll describe who can enter into a contract. Following are the conditions for a person to enter into contract. First, he must be major, he must be of sound mind, he must not be disqualified by any other law. Who is minor? According to the Indian Majority Act, minor is defined as any person under the age of 18 years. Can unsound person enter into contract? For this question, we'll have following points. A person generally of sound mind, occasionally unsound, can enter into contract when he is of sound mind. In other case, a person generally unsound, occasionally sound, can enter into contract when he is sound mind. Who are the person of unsound mind? Mad people, idiots, drunken or intoxicated persons, or crazy persons can be called as persons of unsound mind. Then what is unlawful objectives and void agreements called? Unlawful agreements are the following cases in which there is restraint of an individual from parental rights, restraining a person from undertaking a profession, restraining a person from getting married, restraining an individual from conduction of trade or business which is legal as per the law of the land.
So, students, let us summarize what we have learned in this module. Indian Contract Act of 1872 is very important business law, and knowledge of it to the entrepreneurs can save them legally as well as financially. The understanding of the essentials of the contract and competent parties to the contract is very important. This act considered as the mother of all business laws such as Sales of Goods Act, Contract of Indemnity, Contract of Agency and Contract of Bailment. Thank you very much.